If you are a green card holder, a visa applicant, or someone waiting for a family member to join you in the United States, you need to pay close attention to what just happened. A new travel restriction connected to heightened security measures around the upcoming World Cup has created confusion across embassies, airports, and immigration offices. If you plan to travel, if you have a pending visa interview, if you are adjusting status, if your spouse or child is abroad waiting for approval, this change can affect you in real ways. Stay with me because I'm going to walk you through exactly what changed, when it applies, who it applies to, and how enforcement happens in real life so you can protect your legal status. The recent executive action focuses on suspending the issuance of certain non-immigrant visas for nationals of designated countries during a defined period tied to increased international travel. That means U.S. embassies and consulates in those countries are temporarily pausing approval of new visitor visas and some temporary work visas. The stated reason centers on national security and resource management during high-volume travel events. Whether you agree with that reasoning or not, what matters for you is understanding how it affects immigration processing. First, let's clarify what this does not do. It does not cancel existing green cards. It does not revoke U.S. citizenship. It does not automatically terminate approved immigrant petitions. Lawful permanent residents retain their status unless they abandon it or lose it through formal legal proceedings. Naturalized citizens remain citizens. But the environment of enforcement can become stricter during these periods, and that is where practical complications arise. If you are a green card holder planning international travel, you can still return to the United States using your permanent resident card. However, Customs and Border Protection officers may apply more detailed questioning at entry. Secondary inspection may become more common. Secondary inspection simply means you are directed to a separate area for additional review. It does not mean you are in trouble. It means an officer is reviewing your travel history, documents, and eligibility to re-enter. One of the most common issues green card holders face during heightened scrutiny is extended time abroad. If you remain outside the United States for more than 6 months, officers may question whether you have maintained your permanent residence. If you remain outside for more than 1 year without a re-entry permit, you risk being considered to have abandoned your residency. These rules are not new, but during periods of heightened enforcement, officers may apply them more carefully. For example, imagine a permanent resident who spent 8 months abroad caring for a sick parent. Under normal conditions, that traveler may be questioned briefly and admitted. During heightened screening, the officer may request evidence of continued ties to the U.S., such as employment records, a lease agreement, mortgage statements, or tax filings. Being prepared with documentation can make a significant difference. Now let's talk about visa holders. If you already have a valid B1, B2 tourist visa in your passport and it has not been revoked, you may still travel. However, new visa issuance in affected countries is paused. That means if your visa expires while you are abroad, you may not be able to obtain a new one during the suspension period. This is especially important for students, temporary workers, and exchange visitors. Consider an F1 student studying in Texas whose visa stamp expires this summer. If she travels home to a country subject to the suspension and needs to renew her visa stamp to re-enter, she may face cancellation of her appointment. Her academic status inside the U.S. remains valid, but without a valid visa stamp, she cannot board a plane back. This is why travel planning becomes critical. Employment-based visa holders face similar risks. An H-1B worker inside the United States maintains lawful status as long as the petition remains valid and employment continues. But if that worker leaves the U.S. and needs a new visa stamp to return, and visa issuance is paused in their home country, they may be stuck abroad. The approval notice alone is not enough for re-entry without a visa stamp. Family-based immigration cases are also affected indirectly. If you filed an I-130 petition for a spouse or parent abroad, USCIS may continue processing the petition, but once it reaches the consular stage, visa issuance could be delayed if the consulate is subject to the pause. That means approved cases can sit waiting for interviews. The petition is not denied, but timelines stretch. Adjustment of status cases inside the United States remain under USCIS jurisdiction. If you are eligible to adjust status domestically, the suspension of visa issuance abroad does not directly stop your adjustment application. However, USCIS processing times can fluctuate if agency resources shift due to broader policy changes. Let's discuss airport enforcement more clearly. CBP officers have wide discretion at ports of entry. During heightened alert periods, they may refer more travelers to secondary inspection. In secondary inspection, officers can review your travel history in government databases, verify employment authorization, confirm pending applications, and sometimes examine electronic records. Common mistakes during these periods include traveling without checking document expiration dates, assuming that an approval notice guarantees re-entry, and failing to carry evidence of ongoing employment or school enrollment. Another mistake is believing that rumors online are official policy. Always verify changes through official government announcements. Dual nationals should be cautious as well. If you hold passports from two countries and one is affected by the visa suspension, your classification at entry can depend on which passport you used for your visa. Inconsistent documentation can cause delays. Advanced parole travelers should also plan carefully. If you are adjusting status and leave the U.S. using advanced parole, your return is not based on a visa stamp. The current suspension language focuses on visa issuance, not parole documents. However, parole entry is discretionary. Officers can still question admissibility if other issues exist. Another area of concern involves sponsors and affidavit of support requirements. If you are sponsoring a relative and your joint sponsor lives abroad, travel disruptions may delay document gathering or consular interviews. Income requirements and sponsorship rules remain the same, but logistics become more complicated. Students should maintain communication with their designated school officials. If visa appointments are canceled, schools may provide updated documentation, but they cannot override federal visa issuance rules. Planning ahead is essential. Naturalized citizens are not subject to visa issuance rules. However, if you are petitioning for relatives, delays abroad may affect your family. Emotional stress often increases during these periods because immigration processing already requires patience. It is important to separate confirmed policy from speculation. The order suspends certain visa issuance. It does not eliminate green card protections. It does not create automatic deportations. Removal proceedings still require due process. However, heightened enforcement can expose prior issues. If someone overstayed in the past, provided incorrect information on an application, or traveled extensively without maintaining U.S. ties, those issues may surface during review. Compliance history matters. For individuals facing urgent humanitarian situations such as medical emergencies, discretionary options like expedited processing or humanitarian parole may still exist under current law. Approval depends on documentation and individual circumstances. Immigration systems are interconnected. A temporary visa issuance pause can ripple into family reunification timelines, student enrollment plans, employment continuity, and travel scheduling. That is why preparation matters more than panic. Protecting your legal status means understanding your classification, monitoring expiration dates, avoiding unnecessary travel if you anticipate needing a new visa stamp, and keeping documentation organized. Maintain tax compliance, keep copies of approval notices, save employment verification letters. These small steps reduce risk. If you are unsure how the change affects you, consult official sources or a qualified professional. Avoid relying solely on social media posts or unofficial commentary. Legal status in the United States represents years of effort, documentation, and patience. Policy shifts can feel unsettling, especially when tied to global events like the World Cup that draw international attention. But your stability comes from knowing the specific rules that apply to you and preparing accordingly. Stay informed, review updates from USCIS, the Department of State, and CBP. If you have travel planned, verify your documents before departure. If you have family waiting abroad, monitor consular announcements closely. Your protection lies in compliance, preparation, and clear information. If you have a specific situation that concerns you, ask questions and seek clarity. Immigration law can change, but informed individuals make better decisions.